For conservative Republicans, Kavanaugh is an experienced judge and government lawyer who deserves to sit on the court and will help guide it rightward as he takes the seat of centrist Anthony Kennedy.
But liberal Democrats see Kavanaugh as not just a threat to overturn long-standing progressive judicial precedents, such as Roe v. Wade, but also as a judge compromised by past opinions on executive privilege that could impact the Trump-Russia probe. Here's some of the fireworks from the Kavanaugh hearing.
No one is above the law in our constitutional system. Federalist 69, Hamilton, makes clear all the ways that the executive branch, as designed by the framers of the Constitution, was different from the monarchy. Under our system of government, the executive branch is subject to the law, subject to the court system, and that's an important part of Federalist 69. It's an important part of the constitutional structure. In general, so too, we as judges are separate from the Congress. We are not supposed to be influenced by political pressure from the executive or from the Congress. We are independent. We make decisions based on law, not based on policy, not based on political pressure, not based on the identity of the parties, no matter who you are in our system.
Joining us from Washington is Tyler O'Neill, assistant editor at PJ Media. And in New York, Michael Tobman, a political strategist and former senior aide to Democratic Senator Chuck Schumer. Michael, let me start with you. Obviously, yesterday was a very rough, a very dramatic start. Democrats angry at all those documents withheld from Kavanaugh's time in the George W. Bush White House. Today, when you hear a little more of the substance, what is your view?
Really, this is supposed to be a more deliberate, informed, thoughtful, revealing process than it has been. Not just this confirmation, but really within the past 10 to 15, possibly 20 years, Supreme Court nominations and really any judicial nominations going through the Senate have become predetermined, scripted beauty pageants. So that there is a rich and textured an informative history and paper trail, some of which is appropriate for review, and I believe some of it is not, around Judge Kavanaugh, presents an opportunity to return to a thoughtful, deliberate, informative process, and sadly, we're not taking that opportunity.
Well, let me ask you about that, Tyler, because Democrats are saying that there is a lack of full disclosure there. What is being covered up? Certainly, as we heard, there could be some papers, but have thousands of documents remain out of public view. Is that justified?
Yeah, so what we have in the Kavanaugh hearings is an unprecedented amount of documents, just the plain amount of documents released about Judge Kavanaugh is unprecedented. Democrats are not fighting that. The real issue is that there are a lot of documents that have not been disclosed, mainly because they don't reveal that much about Kavanaugh himself. So the Democrats will come out with these statistics that say, oh, X percentage have not been revealed. A lot of these documents that haven't been revealed are documents that were on Kavanaugh's desk and pushed onward to other people and don't really reveal much about his judicial philosophy, his upstanding character. And what we have seen on record, very plainly available, are those statements, those documents, those rulings that Kavanaugh has stood for.
Democrats in that hearing, though, are saying, well, maybe those documents won't be significant in the end, but we just want the right to look at them. Shouldn't they be able to look at them and not take someone else's word for it? And we're talking, of course, about a decision that will impact the U.S. for decades to come.
So what we're seeing, this is actually a very cunning red herring from the Democrats. The push for as many documents as possible to be made public is just their way of stalling on the key issues. The real reasons why the Democrats oppose Kavanaugh is because he stands for an interpretation of the Constitution on its original text. And what we have, sadly, in this country for almost the past 100 years is this long judicial push to redefine the Constitution in favor of a progressive mantra, a big government redefinition of what the text says. And the Democrats say that Kavanaugh is somehow blowing up this, but what's really going on is Kavanaugh will return to the way the Constitution was written. And that's the thing that they're terrified of. They see in Kavanaugh, they see in every Supreme Court justice a super legislator who will get their pet projects approved as written in the Constitution without congressional or presidential oversight.
Okay,
the Constitution
Tyler,
is very clear on how
let's give Michael a chance to respond, and also to whether we heard Judge Kavanaugh today saying his personal views will not influence his judicial rulings. So, is it even fair to bring up, for example, his prior personal opinions on, for example, executive privilege?
The Constitution is, despite my well-informed, exceptionally articulate, though misguided colleague, the Constitution is an organic, living document that at the time of its adoption, and we had referenced the Federalist Papers, which really were campaign materials in favor of ratification of the Constitution didn't envision issues around privacy and reproductive health and women's health and technology that we face today. So to say the original intent, I think, oversimplifies the issue. However, I will agree with my colleague on this point, and I'll get some angry tweets from my former employer's office. The papers and the work that Judge Kavanaugh did in the White House were in an executive function, and being able to provide an honest, unvarnished opinion to the President of the United States, who he served for as staff secretary, allowed a process that really does not influence Kavanaugh's position and views as a judge and in the judiciary. And I think if any lawyer in that position working in the White House believes that the policies and preferences of the administrator, the executive that they serve, will later disqualify them from a career in the judiciary, we're not going to have the best and the brightest served. So I would say those papers should be perhaps off limits, but for a different reason.
So for this conversation, let's go ahead. Let's put those papers aside. Let's talk a little bit more about the substance, which really is the focus of day 2 of those hearings still happening now on Capitol Hill. Tyler, one of the key issues here that's already been brought up is executive power. On that, Kavanaugh saying that nobody is above the law, but also refusing to answer if the president can be required to respond to a subpoena. Now, we know that all things considered, that is a very pertinent question. Should he be required to answer? Where he stands on that?
Yeah, so there's a lot of misconceptions about Kavanaugh's position on this issue and similar issues. He wrote this law review paper that everyone loves to go to. The thing about this paper is that he clearly says an act of Congress is necessary in order for the presidential immunity that he stands for to be fully enshrined. And the issue of responding to a subpoena is a tricky one because Kavanaugh himself, he was involved in the process against Bill Clinton, but he later seems to have. He came out very strongly against the idea of an independent counsel. And this is not to be confused with the special counsel, which is the role that Robert Mueller is currently pursuing. But when it comes to Kavanaugh's position, it's a lot more nuanced. He should be able to answer more specifically, but the difficulty is, and this is something you run into whenever you're talking about a Supreme Court nomination discussion, is Ruth Bader Ginsburg famously, 70 times said she would not answer where she stands on a specific issue that would come before the Supreme Court.
All right,
this is something
Tyler,
referred to as the Ginsburg rule.
I want to just stop you there because we're running out of time. Michael, your take on that same question.
Ultimately, the issue has gotten so wrapped up in the midterm elections and in posturing for the 2020 presidential election. The inbox on my phone is filled up with fundraising appeals and action alerts for House seats throughout the country and fundraising appeals from people positioning themselves to challenge whoever the Republican nominee is, President Trump running for re-election or somebody else. So it is really impossible to cut through the thicket of noise and positioning to get an accurate read on what is a very nuanced, I agree with my colleague, and complicated position. But certainly Kavanaugh should not be judged on the position he took in a law review article some time ago when facts are just on the ground of change.
If only the actual hearing could be as civilized as this discussion, that could be a good start. Michael Tobman and Tyler O'Neill.